Uh, Good evening, everybody. I'm Collier Neely, the Executive Director for the Landmarks Foundation. This is part 3 of Cultural Crossroads. This is, I think I said the 20th year that we're doing this. Typically, we talk about kind of early Alabama topics, but this year we've decided that we're going to move forward with discussing Reconstruction, and hopefully we can continue this conversation in the following symposiums over the next several years. I want to thank the Alabama Humanities Foundation for supporting this. They have been a constant friend and supporter of the Landmarks Foundation for many years, and for specifically Cultural Crossroads. So it means a great deal. Tonight, we've got Dr. Bertis English. He's going to discuss political conventions during Reconstruction, specifically African American political conventions. And also with us, as usual, we have Dr. Elijah Gaddis from Auburn University, and he will introduce Dr. English.
Wonderful. Thank you, Collier, and thanks especially to Bertis for being here tonight. The talk, the title of Dr. English's talk tonight is Hallmarks of Civility, African American Political Conventions During Alabama Reconstruction, 1865 to 1874. Dr. English, if we haven't said, is a professor of history at Alabama State University, and is himself historical. He has, I have the great good fortune to teach in Auburn University's Department of History, where Dr. English received his PhD, being the first African American person to do so, from that institution and from that department, rather. And since then, he has been one of the great scholars in Alabama and writing on Alabama Reconstruction in particular. I'm going to botch the title of his book from last year, so I won't even try, but encourage everybody to read. It's really a wonderful book on Perry County Reconstruction, and really thinking about, really opened my eyes to really thinking more about the sort of long civil rights movement, and where we can think about the origins of so many of the freedom struggles that we've seen in Alabama for the past going on 2 centuries now. And a really wonderful and resonant book right now that I'll encourage everybody to read. As I've said at the others of these, normally we'd have a little table, at the door for you to buy the books, but unfortunately we have no door and thus no table. But I encourage everyone to read this and everything else that Dr. English writes. I'm going to stop going on because I know we are going to stick to a tight schedule tonight. But I'll ask everyone at home to clap and join me in welcoming Dr. Bertis English. Take it away, Professor.
Professor Gaddis, thank you for that quite embellished, though certainly appreciated introduction, and Director Neely as well, and every person at the Landmarks Foundation of Montgomery. One, congratulations for 20 years of continuous programming that certainly benefits everyone who has the luxury or opportunity to be able to participate. And Professor Gaddis, worry not, there have been several occasions on which I myself have mangled the title as well. But it's Civil Wars, Civil Beings, and Civil Rights in Alabama's Black Belt, the history of Perry County. See how slowly I said that? Because if I went at the conversational tone, which I usually use, I probably would have transposed some of those words. And again, I am delighted to be here. When Professor Gaddis first contacted me about participating, I began instantly to think about some others who would be, I think, great contributors to the series. And fortunately, many, if not all of them, are participating, setting quite a high standard, following Mike Fitzgerald, Richard Bailey. So it is my hope that someone will take something from what I say this evening and make use of it. So what I wish to do, quite frankly, is not deal specifically with predominantly African-American conventions, because it's difficult, I think, for one to truly understand why these conventions came into being without first understanding the sort of general fabric of Alabama coming out of the Civil War, and in fact, the entire Southern country coming out of the Civil War, commencing with the 13th Amendment. So when state legislators in Alabama debated that amendment, many took issue with part of its terms. The vast majority of individuals had no problem with Section 1, which protected a citizen from involuntary servitude if not tried and duly convicted of a crime. However, many lawmakers had a problem with the second section. They took a firm states' right position and declared that Congress should not have the right to enforce the amendment. States' rights, home rule, additional concepts of that type sort of undergirded that idea. But those lawmakers went one step further in bolstering their general position on state rights. In deleting a line from the 1819 Constitution declaring all freedmen who formed a social compact, they said, had the same rights and privileges of citizenship. The legislators also passed a resolution indicating that any future ratification of the 13th Amendment would not mean that they agreed that Congress should have a right to determine the political condition of free people. It was only with those qualifications that Alabama lawmakers ratified the 13th Amendment on December 2, 1865. And then, of course, Georgia and North Carolina would follow, allowing federal lawmakers the ability to write the amendment into the Constitution. So the 13th Amendment is ratified in Alabama. What happens? Well, it takes care essentially of the enslaving of people in the state, but what about the citizenship of those formerly enslaved individuals? Male suffrage, one of the main topics of conversation during predominantly African-American conventions, was a foremost issue. The amendment continued to limit the vote primarily to law-abiding white men. Black folk, you're free, but you don't have the right to participate in all political processes. The 13th Amendment did not change the way that congressional representation or the number of votes a state had in the Electoral College was calculated. So if federal officials continued to use population to decide how many seats a state received in the House of Representatives, the infusion of more than 400,000, one metric or one census suggested about 422,000 African Americans, or at least legally freed persons of African descent in Alabama, would be used to calculate the numbers that I just mentioned. So again, you bring all of these persons in for the purpose of calculating population, but you don't enfranchise them. So essentially, they would have been given, white persons, the ability to essentially control the House and hence the region's politics. Voting congresspersons into office, the vast majority of informed Black persons and by ethnic persons knew, essentially would allow the Confederate phoenix to rise. And that's something, of course, they didn't want to happen. So Alabama's most knowledgeable African Americans, or again, I'm using people of African descent because from May, when the Civil War ended officially in the state, and until December, when the 13th Amendment was ratified by state lawmakers, Black persons and bi-ethnic persons were, again, legally free, but they weren't complete citizens. So during that time, those informed folk decided they were not going to let lawmakers in Montgomery, the state capital, or those in Washington, D.C., decide their collective fate. As early as July or August 1865, there were several newspapers throughout the South and the country that were printing information about a small group of literate freedmen in Alabama encouraging political activity. Some members of the group were somewhat educated academically. Most were agrarian, and virtually all were devoted Judeo-Christians. They understood the value of discussing politics with other free people who could read and write. But they also understood the value of discussing such matters with those who lacked proper schooling. Individuals might have been illiterate, but they had common sense aplenty. Practical experience allowed them not only to listen and to learn about politics from literate free persons, but also to contribute to the general discussion by expressing their own views. So there were two mobilians, a white person and a black person, who essentially led a broad campaign for African-American political activity immediately following the Civil War. Lawrence Berry and Elijah Branch. Berry was a formerly enslaved person, as well as a minister and an officer in the African Methodist Episcopal Zion Church, or the AME Zion Church. He also was a Union League official and a field agent for the Black-owned Mobile Nationalist newspaper, the first publication of its type in the state, Branch was a white field agent for the Nationalists. He also was an educator, a Union War veteran, a one-time American Missionary Association, or AMA agent, and he was born in the North. Together, they helped organize a statewide political convention for free people in Mobile, the only seaport locality in the state. Almost 60 delegates met in November as white lawmakers debated essentially the 13th Amendment. Most of those delegates to that Mobile meeting were ministers, clergy persons, preachers. The vast majority resided in the central part of the state, the southern part of the state. And E.S. Wynn, who was an elder in the AME Zion Church, presided. Approving a resolution that essentially encouraged peace and goodwill among all Americans, but white Southerners in particular, was one of the Mobile delegates' first official acts. In an attempt to achieve that goal, they agreed to be dutiful laborers for any individual and all individuals who paid a fair wage or wages. They also said that they would not seize anyone's property without providing an equivalent. You know, that was an idea that you'd have these Black persons just running and ethnic persons running rampage, just taking land, conscripting land and so forth and other property. Not the case. The delegation decided, however, that its members would not go without a single right or privilege that a white person enjoyed, and that's female citizens as well. Academic education, public office holding, the ability to create or to expand independent churches, and voting opportunities in political elections were primary demands. Delegates considered each one of those items, among others, critical to the liberties that they presumed they would gain if Alabama lawmakers, white lawmakers, state lawmakers ratified the 13th Amendment. And here's something that's important to me. In fact, if we were to expand this discussion to just conventions, period, we would get into religious conventions, but we're not. We'll stay largely in politics. But those delegates who met in Mobile said that they intended to accomplish each goal that they set through the abilities that God gave them. Now, of no surprise, many white Alabamians thought that Mobile Convention was, as they would describe it, radical. That's always a term that just irks me, quite frankly, because I say, well, radical meaning what? Someone gonna jump out of pop up out of a tent or something? And well, anyway, I'm getting off script here, so to speak. So white members of the Democratic Party in Alabama were especially enraged at that convention. And of all the things that those delegates requested, universal male suffrage really bothered the Democrats, some of whom had not gotten over a similar request that a separate group of Mobilians had made in September. So Alabama's Freedmen's Bureau Assistant Commissioner, a guy by the name of Wager Swain, a white Republican, a Union Army officer, a Yale graduate whose father Noah Swain sat on the United States Supreme Court at the time, communicated that September convention's appeal to lawmakers who were meeting at the State Constitutional Convention in Montgomery. One white supporter of the appeal said there was nothing that other white individuals in the state had to worry about because the appeal included educational and property qualifications that only a small number of Black or bi-ethnic persons could meet anyhow. Therefore, there was no reason for a power grab. It did not matter whether federal officials denied most former Confederates amnesty or if former Confederates themselves refused to take the federal loyalty oath. Despite those facts, the lawmakers tabled the matter of Black male voting by voice vote and never took up the matter again. So again, in attempting to contextualize the sort of need for many of these predominantly Black and bi-ethnic conventions, one has to take these sorts of ideas, I think, into consideration, as well as the fact that the general position among white lawmakers regarding only men of their ethnicity voting did not change from September, the Constitutional Convention, to November, when those Black and bi-ethnic folk, along with others, all men, met in Mobile. Most white state lawmakers made clear their opposition by passing a set of laws that people throughout the South and the country term Black codes. I'm not rather aware of any specific discussion among those African Americans who attended the November convention that Lawrence Branch and Elijah Berry called in Mobile, but the idea that at least one discussion about the Black codes didn't take place, I think, would be nonsensical. Alabama's governor, Robert Patton, who was a veteran Democratic politico, did not veto the Black codes until December 1865 and into January 1866. So the idea that someone had something to say about those Black codes, those very restrictive laws, vagrancy laws, and other movement, for example, even buying liquor or sermonizing, whipping, all of those were contained in the proposed Black codes of Alabama, but Black codes that, at least in terms of actual nomenclature, Black codes themselves never became law. Now, again, that's in the actual naming of the codes, but there were other laws that were contained in those Black codes, which the drafters essentially wrote to perpetuate the 1852 state slave code. But again, they did not identify directly persons of African descent. So anyway, a number of local political meetings took place in Alabama from Patton's veto through early 1867. Wage labor, passage of a federal Reconstruction Act establishing military rule in Alabama and 9 other former Confederate states, those that had not ratified the 14th Amendment. Tenancy, the 14th Amendment itself affirming citizenship to nearly all people born on American soil or naturalized. Federal extension of the Freedmen's Bureau. Ratification of a federal civil rights bill, concretizing terms of the 13th Amendment, the 14th Amendment, if adopted, and ending the Black codes. Convict leasing, yet another one of those major topics of discussion. However, the next statewide, predominantly African-American convention would not take place until March 1867. Once again, Branch and Berry organized the convention, which opened on March 4, 2 days after the Republican-controlled Congress passed the Reconstruction Act. So what did these individuals discuss primarily? Ethnic unity, white domination of society, non-white voters' purported ignorance. These sorts of ideas were central to the meeting that took place in March. John Carraway, a Union war veteran and a Mobile nationalist agent, originally from North Carolina, not Alabama, declared that African Americans could be as friendly to socially and to politically, culturally conservative white people as they were to moderate and to liberal white people. But only African Americans themselves, Caraway said, should determine their collective fate. Berry was more militant than Caraway, and they had disagreed about the sort of development, the advancement of the nationalists. But Berry added that Black and bi-ethnic folk were smart enough to understand citizenship, and they were determined to enjoy it. So following that March meeting in Mobile, there were a number of smaller meetings, conventions they were called, or conferences that were held throughout both counties and municipalities. Montgomery, for example, was one. At the meeting in Florence, in the northern portion of the state, individuals met in April to nominate the one non-white county registrar of Lauderdale that federal law mandated. So the attendees were very aware that they had to handle these new societal obligations wisely. And they decided that a man by the name of John Rapier Sr. should be the county registrar. He was hardworking, he was literate, he was a property owner and had owned enslaved people before that. That's another subject. He would be the individual who would serve. He had been legally free since 1829, a mere decade after federal lawmakers granted Alabama statehood. But his appointment is important, and I think bears witness to the influence of some of these conventions. With him becoming county registrar of Lauderdale, he held the first prominent political position for a person of African ancestry in Alabama. And those men who were responsible for his appointment truly needed the cheer that his position engendered. In March, moving back just a bit, approximately 1 month before his nomination, white, Black, and bi-ethnic Republicans held a conference in Montgomery. Again, I'm going to mention this to sort of flesh out again the reason for the predominantly African-American conference and their necessity. But this Republican meeting in Montgomery, March 25, the date. Once again, federal decisions had a direct impact on local affairs. For 2 days before that meeting, on March 23rd, Congressman passed the second Reconstruction Act. It essentially clarified voting requirements for the 10 states under martial law. The act authorized federal employees together with local and state officials to essentially convene registration boards and to supervise the electing of delegates to those forthcoming state constitutional conventions. Now, some historians have contended that that March meeting among those ethnically mixed Republicans, white Republicans and Black Republicans, was the first time that a group of that type came together as, quote, political equals, unquote. But that idea is questionable. The Republicans met, and that's certain, but white persons gave speeches. So in a May 1867 convention that Berry and Branch hosted in Mobile, you got a game. Mobile was the place to hold meetings, I guess. You go down there, I get warm and right by the water, I guess. You can do all sorts of other things. Anyway, this May 1867 meeting, which was held in a church, turned out to be one of the largest predominantly African-American conventions to date in Alabama. Delegates from at least 13 counties, some folks say as many as 15 attended. I'm not going to get in that sort of weed. Instead, simply make clear how informed about political procedure, decorum, and so forth these individuals were, despite many Democrats in particular, and some socially and politically and culturally conservative white persons saying that these were just a bunch of ignorant, a name I shall not say, but it rhymes with biggers who were meeting for no real reason. The first morning session of that May 1867 convention followed the usual protocol, with one exception. Persons registered, and then they held a brief religious service. Next, they elected officers. Holland Thompson was president, John Caraway was secretary, And again, both of those individuals were exceptional figures. Thompson was a leading Black Baptist. He was an agent for the Mobile Nationalists, as well as one of South Alabama's most influential Union leaders. Caraway not only served in the 54th Massachusetts Regiment, that famous unit that Frederick Douglass Sr. had sort of pressured Abraham Lincoln into creating to facilitate Black and bi-ethnic military participation during the war. But Caraway also served as president of a statewide newspaper society, among other positions. Again, these were individuals who would have been able to hold their own in any discussion, regardless of the ethnicity of individuals. So what did they do at the May meeting? Among other things, they sort of reiterated their support for the Republican Party. And I mean, it was overwhelming. There was an unofficial delegate from Mobile by the name of Albert Griffin. He was a white man, a printer, editor at the Nationalist. And he sort of summed up the spirit of the meeting when he told delegates that Alabama's destiny was in Republicans' hands and Republicans' destiny were in African Americans' hands. Now, that idea conflicted significantly with the views of certain white persons in the state. They thought that Black and bi-ethnic members of the Republican Party had gotten so fed up with being treated as essentially second-tier members of the Republican Party that those African Americans wanted to create their own political organization. There was a newspaper in New Orleans called the Tribune. It was the first daily newspaper in the country owned and operated entirely by African Americans. And it helped dispel that myth about Black and bi-ethnic Republicans wanting to form an independent party. The editor was a bi-ethnic person who had once lived in Mobile. His name was Moses Avery. And he confirmed that securing harmonious relations with white Republicans was the only reason that Berry and Branch had organized that May convention in the first place. And he was right. Relatively few Black or bi-ethnic men in Alabama wanted to create a so-called colored man's party. Quite the opposite. Most desired to, as I sort of stated initially, to sort of foster peace and harmony and bi-ethnic cooperation among all citizens. Because Black men formed a numerical majority among Republicans in the state, a Montgomery newspaper called the Alabama State Journal, it was one of the leading Republican-leaning sheets in the state. It predicted that African Americans would comprise as much as 9/10 of the party if local Republican leaders came together to form a statewide organization. And it was of no surprise that a number of African American men were optimistic about that possibility. They also were optimistic that they themselves would have some relatively influential roles in that process. Several of their European American contemporaries were quite skeptical. According to one man, Northern-born Republicans, I won't call them carpetbaggers, I won't call them a number of other derogatory names that were given, but the Northern-born white Republicans in particular were trying to force equality on their Southern-born white party mates. The man knew that there was going to be a statewide meeting that would be held in June 1867 to decide whether a statewide Republican Party would be formed. But for him, he said, sitting next to someone who was not white would be a bitter pill to swallow. So again, you have these individuals who are coming together in 1867 in June, about 150 individuals altogether. Of that number, approximately 100 of them were African Americans. Many of them had been influential participants in the predominantly African American convention, campaign, or movement at this time. So the party platform that they put together at the statewide Republican meeting included terms for free speech, free press, and also free schools. The proposal likewise contained the term consistent with the 13th Amendment, the 14th Amendment, the 1866 Civil Rights Law, both the first and the second Reconstruction Acts, and other federal legislation banning discrimination on account of one's ethnicity or on account of one's previous condition of servitude. The 18 individuals who attended Alabama State Constitutional Convention later during that year were entirely supportive of the statewide Republican Party's founding principles, but getting most self-proclaimed Southern men in their party, that is white natives who were conservative socially, politically, and culturally, to do so was a tough task. Democrats were solidly against any measure that even smacked of universal equality. So you have essentially a situation where individuals who once were important to the then African-American political conventions who are also taking part in the Alabama State Constitutional Convention in 1867. But for the most part, those individuals were there and served in a more symbolic purpose than any material purpose. Only three individuals gave multiple speeches. Three individuals that is of African ancestry. John Carraway was one, Obed Gregory was a second, and the third individual was from Lauderdale County, and his name was James Rapier, son of John. All the same, the Constitution that their fellow delegates and they created was relatively progressive, especially regarding male suffrage, right, which the Constitution guaranteed. The 1867 state constitution that would be ratified in 1868 also contained protections for women, homesteading and other property, as well as personal property protections as well. But the most lasting contribution of that 1867 constitution that would be ratified in 1868 was public education. A number of individuals, historians, and other scholars have said that that 1867 Constitution mandated segregated facilities, but it didn't. Here was the catch, so to speak. If parents in a particular locality voted to approve desegregation or outright integrated educational facilities, those facilities were legal. Of course, one doesn't have to guess today how many times or how many places that would take place. But that 1867 with regard to education is important for yet another reason. And this reason too, I think, spells out the importance of those predominantly African-American conventions. Those persons of African descent who pressed for a public, a genuine public educational system in Alabama had no issue whatsoever with those same facilities schooling at the state's expense poor white persons. And for the first time in the state's history, those individuals could be educated academically at state expense. So what are some areas then in which those African Americans who had participated in earlier, predominantly African American conventions did not do as well constitutionally in 1867 and 1868? By ethnic, so to speak, marriage was one place. And the debate continues to rage about how many persons of African descent would have wanted these things anyway, be that as it may. It was written into state law, into the revised code of Alabama in particular, that any two persons of different ancestries who wed or who even live together, particularly in fornication, this document reads, would be liable to either hard labor, and that's a specific terminology that's used for the county where they attempted to wed, or they could be liable to from 2 to 7 years of hard labor in a state penitentiary. The Alabama Supreme Court did not rule that 1866 federal civil rights law meant that an individual could wed whomever he or she wanted without regard to one's skin color until 1872. So that same year, okay, there were a number of political conventions that were either organized by or attended in large number by persons of African ancestry. One was statewide in 1872. Again, Montgomery was the venue. Fair wages, including recurrent calls for a minimum wage, something that the country would not get until however many years thereafter, and something that's still being discussed today. So I guess that's another long-standing sort of importance of these African-American conventions. But making, for example, getting redress in state courts for unfair wages or some other type of compensation for labor was yet another item that was discussed at this statewide, predominantly African-American convention. Healthy working conditions and reparations, primarily in the form of land redistribution. The possibility of immigrating to the Midwest or even to Africa was yet another subject, or two other subjects that were discussed. But more than anything else, individuals simply wanted to be treated justly in not only the courts, but also in private places as well in the state. Alexander H. Curtis, though, who was a bi-ethnic businessman, he was a barber, he owned a store, he was a politician who had served as county registrar of Perry County in the Black Belt, and who in 1872 was trustee or a trustee at the only publicly sponsored normal school meaning a teacher's training institute for African-American students in not only Alabama, but the entire South. Also was a member of the Alabama House. He gave a speech about temperance at this 1872 statewide meeting that I also think is important. Essentially what he said was that drinking whiskey, his words, right? I guess other types of alcohol were fine, but drinking whiskey hindered advancement by keeping one in want. Curtis likewise said that, again, drinking whiskey, his words, also set a bad example for youth, particularly one's child or children. Curtis himself opposed immigration, believing that the land that persons of African descent had cultivated since enslavement belonged rightfully to them, their descendants, or to whomever else they wanted to bequeath it. And unwilling to remain in his proverbial place beneath white people, Curtis said that he would call no mortal man master. Instead, he would display every attribute of a responsible citizen. That act, he concluded, would earn him respect for or from anyone whose respect was worth enjoying. So we whiz forward to 1873 when Reconstruction in Alabama essentially is about to come to a permanent end. Reconstruction, as Michael Fitzgerald has stated, actually was two-part in the state. 1865, post-war Reconstruction, 1865 to 1870, then it stopped essentially and resumed. I'm getting my dates mixed up here. 1870, stopped 72, 74. We'll figure it out later because I'll probably file that up too. So 1873, he extended his own role in the predominantly African-American convention movement. About midway through February, while serving in the Alabama Senate, to which voters in Perry County had elected him in November, a group of his fellow state legislators, and he formalized the Alabama Equal Rights Association. This was really the epitome of the predominantly African-American convention movement in the state. Every member of this group belonged to the Republican Party. They elected African-Americans James Rapier of Lauderdale County as president, James K. Green of Hale County as vice president, and a Afro-Creole, so to speak, of Mobile County by the name of Philip Joseph was second vice president. Curtis was treasurer. Of all those four officers, Rapier was the most influential. In addition to owning and to operating a Mobile newspaper called the Republican Sentinel, he owned real estate in several Alabama counties and served as vice president of a countrywide predominantly African-American labor union. Yet another item with regard to the African-American convention movement in Alabama is extremely important, but I have to come to a close, so I must stick with the political conventions. Rapier, furthermore, was a congressman-elect in November 18th, or as of November 1872. He simply could not take his seat until Congress opened in December 1873. In any event, the February 1873 meeting of the Alabama Equal Rights Association, there are a number of scholars who've suggested that African Americans did not conduct sort of a sustained drive for integrated learning centers, but that idea too is questionable. One needs to look no further than the Alabama Equal Rights Association to understand this. A number of its members call for desegregation, if not outright integrated educational facilities. James K. Green belonged to that group. He said during the meeting that the day was approaching fast when Alabama youth of different ethnicities would study, play, and eat together without many persons caring about their act. Well, most Democrats and many conservative white Republicans dreaded the day that Green envisioned, a day the Supreme Court seemed to forestall or postpone in April 1873. That month, the court ruled in a 5-4 decision. It's a case called the Slaughterhouse about butchers in New Orleans, but that's neither here nor there. Importance is that, according to this ruling, a state government had a constitutional right to not only determine, but also to police the privileges and the immunities of its citizens. Essentially, what that ruling did was to invalidate the 14th Amendment's protection clause. Congressmen had used that particular clause to sort of combat an assortment of discriminatory practices in labor, the penal system, voting, and an assortment of other areas. And of course, oftentimes African Americans were victims of such discrimination, hence the reason why so many African Americans were concerned about this particular ruling. So we move forward and understanding why many members of the Alabama Equal Rights Association did not press too hard for desegregation or integration in education or in a number of other areas. In addition to the possibility of white backlash, they also believe that socially and politically and culturally conservative white members of the Republican Party, and again, the vast majority, if not all of these persons who participated in that association were Republicans. They pressed too hard for that radical stance, then those white conservative Republicans would oppose what they were doing, thus leaving them open rather to physical brutality, to additional verbal abuse, emotional distress, and a number of other things that would not facilitate Black and bi-ethnic advancement. They still recommitted themselves to the Republican Party, however. They likewise supported a pending federal civil rights bill, which of course would not become law until 1865, and did not have much success or much utility in Alabama because Democratic and conservative white Republican lawmakers just ignored it. But they also did one other thing, and that is they made clear that the equality issue was not going to go anywhere, not even within the Republican Party. And indeed, the equality issue, or the so-called Negro problem, or the Negro Question, dominated the 1874 statewide convention in Montgomery. Though claiming that inclusiveness characterized their Republican Party, conservative white members mandated that their ticket be lily white. Not a single individual was non-white. At least in 1870, they allowed James T. Rapier to vie for Secretary of State. Anyway, the same white Republicans in 1874 ignored advice from the Alabama Equal Rights Association regarding integrated or desegregated at a minimum public facilities, not just educational facilities. And they opposed ratification of any state or federal civil rights bill. White Republicans who lived in the Tennessee Valley were most vociferous about civil rights. A group from that sub-region even threatened to form a splinter group within the Republican Party called the Citizens Union Party if individuals continued to press for integration. Divided and facing a high level of physical violence and political fraud in Alabama, the Republican Party lost, or more accurately, the Republican Party got cheated of the governorship nearly, if not every statewide office and many local positions in 1874. So in effect, the second Reconstruction of Alabama, again, from 1865 through 1870, forgive me, then 1872, 1874, we come in. See, Professor Gaddis was talking about bungling my book title. Here I am bungling the chronology of Reconstruction in event. 1874 as I close. Following September, supermajority of largely former Confederates met in Montgomery, drafted the third state constitution since the Civil War. Unlike the preceding Constitutional Convention, that is that one event that was held in 1867, the controlling delegation of Democrats wrote segregated educational institutions into the organic law. Those comprising the supermajority in the next Constitutional Convention, held in 1901, were even more aggressive in their unified attempt to maintain white supremacy. They disenfranchised approximately 98, some folks say as many as 98% of the African-American citizenry of Alabama. Anyone who had not served in the military and could prove that service essentially was disqualified. One must also remember that a number of poor white persons were disqualified and disenfranchised in 1901 as well. To this date, efforts to erase shadows of the color line and realize full equality, the primary goal of those predominantly African-American political conventions in Alabama, remains unsuccessful. The state continues to have racist or ethnically biased language in its organic law. Thank you.